Okay. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Myra Hippolyte. Also, our presenting partner with Lone Star Legal Aid representing today is Ms. Kimberly DK, who's going to be presenting the information on evictions and knowing your rights. But also included in the partnership is Earl Carl Institute, Houston Volunteer Lawyers, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, and the Houston Bar Association. And for those that are not aware, the Houston Bar Association does sponsor any of the courses where you see a course number beside the title of the name. Attorneys have the opportunity to take advantage of free CLE credits for participating in the presentation today. So definitely make sure that you take advantage of that. But just to give you a quick little brief background, A Month of Service is a collaboration of all 8 of these different organizations. We come together on a monthly basis and offer a variety of different workshops, information, and resources relative to asset building, asset protection, community empowerment, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there that don't necessarily have access or know where to go for resources or particular information. So we decided to collaborate several years ago and come together collectively to offer the information and these services to the communities that we do all serve, since we do have that in common. In addition to that, we wanted to create a larger impact and reach even more people. And we've had that opportunity since we've had to convert to a virtual platform and reach out to people that are in, throughout the city, around it, surrounding counties, as well as throughout the entire state of Texas. So know that the information for the legal workshops that we present is relative to the entire state and not just for the city of Houston or for Harris County. So, so do please keep that in mind. But this is your opportunity to ask whatever questions it is that you may have of the professionals that we have that are presenting for you through all of these workshops. However, we do ask that you try to keep your questions to be as general as you possibly can, not to cross the line with giving legal advice, as the information that is presented here today and throughout the presentations are for educational purposes only and not to be considered legal advice. However, we do encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourselves in need of any civil legal assistance or needing any help with evictions or landlord-tenant issues. So, and Ms. DK is going to go into a little bit more detail about the other services that are available from Lone Star Legal Aid. So if you are joining us via Zoom, please feel free to type your question into the chat. Or you can wait until the end and unmute yourself and ask your questions directly. However, if you are also joining us on Facebook, please feel free to type your question into the comment section and we'll make sure that your question is read aloud at the end as well. So again, just want to kind of remind everybody that we do record this session as well as broadcast live on our social media platform at Amos Houston TX on Facebook. So we want to try to protect your privacy as much as possible by asking that your questions are general and not to divulge any personal detail information so that everybody actually has access to. So we definitely don't want to have that information getting out there. But again, this is an opportunity for you to ask questions of the professionals. We are grateful that you guys are here to join us again this month, and thank you for continuing to participate and to come back and join and support the A Month of Service collaboration. So without further ado, we're going to go ahead and go on into our introductions and into our presentation. So we're going to have Ms. Myra with the City of Houston go ahead and introduce and.
Good afternoon, everyone. Hi, my name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhoods on behalf of Mayor Sylvester Turner and Director Takasha Francis. We want to welcome you to the Month of Service Partnership virtual workshops. This is all about giving back free information to the Houston Harris County community. Guys, we are out in the A-Leaf Neighborhood Community Center. It is gorgeous out here. We are pre-assessing the community for free or low-cost legal assistance. Thanks for the month of service partnerships. We're always giving back to all the Harris County and Houston and Harris County community. Guys, have a great day, and it's a beautiful day here in Houston.
All right. Kimberly, you want to go ahead and introduce, and you can go ahead and get started with your presentation. You're on mute too.
Okay, hello. My name is Kimberly DK, and I'm an attorney with Lone Star Legal Aid's Eviction Right to Counsel Unit. Today, we're going to go over some tenants' rights and things you should know in the event that you're having any issues with paying your rent, or you're talking to your landlord about any eviction-related issues. We're going to give some background and talk about other things that might happen that we would love for you guys to know about. But first, I'm with Lone Star Legal Aid, which is a 501c3 nonprofit law firm, with a rich and deeply respected history of advocacy on behalf of low-income and underserved populations, beginning with the Houston Legal Aid Clinic in 1948 and East Texas Legal Services in 1977. In order for us to help, you must go through an application process, and you can apply 24 hours a day, 7 days a week by going online. Our website is www.lonestarlegal.org. You can also apply by calling the toll-free number listed for the office that serves you. So Lone Star Legal Aid is a full-service civil law firm that serves about 72 counties in this area of Texas. And so you can look online and see what office is closest to you, especially if you're in the rural areas, and give them a call. Each Lone Star Legal Aid office has a designated time for non-emergency applications taken over the phone. Due to COVID-19, we are not currently scheduling in-person application appointments. And so we do encourage you to apply online. You get a faster return on those phone calls, but if you don't have access to that, please definitely look us up and give us a call. So we're going to go over some information contained in your leases, terms you should know, and rights you have regarding your lease, how to terminate the lease, how to receive a notice to vacate, lockouts and utility shutoffs, and the rights contained within those situations. We're going to briefly talk about security deposits, and then we'll go into forcible detainer suits, which are known as evictions, and the appeals process. Now, again, this is legal information. It's not intended to be used as legal advice, but we'll be happy to answer questions after this, but this is just a presentation for legal information. Now, in Texas, you are allowed to enter both oral and written leases and have those leases recognized as true contracts, because a lease agreement is an agreement between a landlord and a tenant that establishes the rules regarding the use and occupancy of a dwelling. So if you're talking to someone, hey, can I stay here for a few months? Yeah, sure. You know, these are the rules. You're going to pay this much amount of money on the first or second. That's perfectly, that is a contract that the other party can be bound to and can be enforced. However, if the lease term is for longer than a year, then it must be in writing. Your lease is a contract, which means the terms are negotiable. So never feel that you are in a place where you can't ask questions, especially if you're working with like an independent individual owner. Ask questions, speak about terms that are more important to you to see if there's an agreement that both of you guys can work with. No matter how official that lease looks, make sure you ask questions and see if any of those terms are flexible. And you have a right to a copy of your lease. And this is under the Texas Property Code. You have a right to receive a copy of your lease within 3 days of it being signed by all parties. And if there's multiple people on the lease, then at least one of the tenants must receive a complete copy of the lease. And if another tenant doesn't receive one, if you don't receive a copy, make sure you ask for it in writing so that you can get that copy too as soon as possible. Now, when you receive your full copy of your lease, make sure to read it over and make note of any important clauses that you think might affect you. And some of the ones I have posted here are some of the ones that I think are most important. But of course, you want to go through and understand what you're bound by. If you have children, if there are community rules, if you have a pet, you definitely want to look at those clauses and those terms in your lease so you understand what you've promised to do and what your landlord has promised to do. Now, you're going to want to note, of course, your monthly rent, when and where to make those payments. If you might see yourself having to deal with late fees or insufficient fund fees, you definitely want to know how much those are and how payments after a late fee has been posted, how your payments will be applied. You want to know if next month you're paying full rent, do you have an option to pay late fees separate, or must they be in full? And will any amount you pay, will they be put on utilities or late fees first, or go to your rent? You definitely want to know and understand that as you're planning to pay your rent each month. And also, as you are planning to pay, let's say if you're on a fixed income and you receive any type of Social Security or other type of, weird payment schedule, especially with people working from home and working for different types of companies, you want to also talk to your landlord about when and where you can make payments, or if there is some flexibility on your payment schedule. Generally, you have to pay on the 1st, late by the 3rd, late by the 4th, but like we said, these are contracts and these terms are flexible, so just don't hesitate to ask. You also want to make a note of your initial lease term and understand after that 6 months, 9 months, 13 months, what happens? Do you roll over automatically on a month-to-month? Is that month-to-month status going to incur any type of month-to-month fee? Will you go to market value? You need to know those things and make note of them so you understand kind of what you want to do at the end of your lease. You want to make note of community rules and policies or any signed addendums, especially if you have any HUD or housing authority agreements or any concessions. You do have to respect the community rules. Even if you have kids, you want to know if they can play outside or if there's quiet hours, so that you aren't in any type of violation or anything that can count itself as a breach to the community rules or any addendums. You also want to know about those concessions. Will you have to pay that back if you run into an issue, or how are they being applied to your lease? You definitely want to understand how that works, so that if there's any breach in the future, you understand if any type of move-in specials or concessions will have to be paid back. You'll want to know your acts of default. Of course, failing to pay rent, you've breached the contract. You also want to know what your landlord also considers other material breaches. Some might take unauthorized tenancies and different occupants coming in and out of your house as a material breach, or something that can, repeated offenses can lend themselves to being a material breach. You want to know that, because you want to be able to talk to your landlord. Hey, I do have family that's often coming in. How do I notify you so this doesn't become a problem? You also want to know if early termination or holding over, what those defaults look like. So if you are leaving or you need to leave within the initial lease term, that's considered an early termination. And you want to know how your landlord feels about that. Is it a one-time cost? Will you have to pay the rest of the lease? You definitely want to know those terms. Next, you'll want to understand all the timelines. You want to know how much notice of lease renewal or a non-renewal. How much time do you have to give your landlord versus how much time your landlord has to give you? Any other types of notices of defaults, whether it's breaking community rules or other issues, as well as a notice to vacate. Is your landlord supposed to give you a 24-hour, a 3-day, a 30-day? You definitely want to make note of those timelines so that whether you or your landlord starts to exercise those rights, you understand what those timelines look like. Now, after the initial lease term, both the landlord and the tenant have the right to terminate the lease as long as those notice timelines are respected. Your lease will contain language regarding the timeline of termination and when notice must be provided by either party. Now, if you are provided notice, or if you give your landlord notice that you're going to move out after your lease term or after an extra month or whatever you guys decide, if you fail to leave after that date, that termination date, you're considered a holdover tenant. And when you hold over, you do run the risk of being evicted by being a holdover tenant. So you want to make sure if you provide any notice to your landlord, or your landlord provides any notice to you, you vacate by that time, because you could be in breach that could give rise to a lawsuit. Now, except in very special circumstances, you can't make your landlord renew your lease, just like your landlord can't make you renew your lease. So make sure if you do get a notice of non-renewal, for example, you don't try to fight it. Maybe try to understand it, but understand that if you fail to leave, you could be in breach of your agreement. And of course, terminating the lease during the initial lease term is deemed an early termination. And when you terminate your lease early without consent, this may subject the tenant to certain fees and penalties. So if you do need to leave, and we'll talk about some of the rights you have to terminate a lease early. If you leave without consent, you could incur costs, but of course you and your landlord can agree, hey, this isn't working, or I'm having an issue, or I can't afford rent anymore, and you might be able to get into some type of agreement, but make sure any type of agreement you have after you sign the lease is done in writing so that you protect yourself for any type of future dispute. Now, the right to early termination. In specific circumstances, a tenant can terminate the lease and avoid certain liabilities. And your lease is required, not supposed to, your lease is required to give some of these notices because these are statutory rights. So if you're dealing with family violence on the property, or certain sex offenses or stalking happen on the property, you have a right, a statutory right in the Texas Property Code to provide your landlord with certain information so that you can leave the property and avoid any future liabilities of having to pay rent or anything like that. Of course, if a tenant passes away, you avoid future liability, but past due obligations such as unpaid rent, damages beyond normal wear and tear, those are still recoverable by your landlord against the estate. Your lease is not required to note this one, but it's usually in there, of course, and it does have a Texas Property Code rule. And then, of course, certain decisions related to military service. If you are being deployed or have service papers, you can provide certain information to your landlord and avoid liability under the lease, or to terminate the lease as a whole. And in certain situations, your landlord and tenant can agree to waive this right, but you don't have to, you shouldn't. But in order to terminate your lease, vacate the premises, and avoid liability, you need to review each of the statutes above. Each statute will tell you what documentation needs to be provided to the landlord to start that process. And if you do want to pull up that information and have questions, of course, reach out to a legal professional to help get you through understanding what documents and what information you need to provide. I've changed the order a little bit because I want to put in here, you do not want to withhold rent. Even if you want to terminate the lease, even if you think you have a right to terminate the lease, or if you feel like anything's going wrong, just do not withhold rent. In certain circumstances, this may seem like a good idea, but it is a self-help remedy that is very rarely done correctly and will set you up for an eviction lawsuit. Because in order to maintain certain rights, you must be current on your rent. For example, when it comes to having repairs made on your property, once you fall behind on rent, your landlord does not have to make repairs to your apartment or home. So withholding the rent prematurely, instead of getting a repair done, you'll set yourself up for an eviction for non-payment of rent. So if you are having issues with getting repairs, for example, especially if they threaten the health and safety of an ordinary tenant, send your landlord a request for repairs detailing exactly what's going on, what repairs need to be done, and send it via certified mail. Once that's in the mail, make sure you keep your copies and contact a legal professional. It's just there are several steps between requesting a repair and obtaining your right to withhold rent. So it's just best to send your letter and contact a professional to help you get through the rest of it. We would hate for you to lose out on rights that we could help you obtain. You know, we can get those repairs and we can start the process to even maybe terminate your lease, but you need to stay current on your rent. Now, your lease can also be terminated by your landlord because a breach or a default has occurred. So a breach of a lease is any violation of the lease terms, conditions, rules, or other provisions listed, and your lease will let you know what that information is, what those breaches are. Common default by resident terms, which are, in your lease, what tells you if a tenant performs these things, we can terminate these defaults. Under these defaults, of course, failure to pay rent by the date stated in the lease, repeated violations of community policies, having unauthorized tenants, any criminal activity by a tenant or the occupants or guests of a tenant, and holding over. So I definitely always want to bring attention to when there's criminal activity or if there's any unauthorized tenants, you will be responsible for what those individuals do while they're on the property. So you want to make sure that you run a tight ship and make sure everyone's doing what they need to do and following the community rules so you can stay on the property and avoid any type of issue in the future. But if a breach does occur, the landlord must provide you proper written notice before they can start filing an eviction lawsuit. So a notice to vacate is what's needed in order to begin the eviction process, but this proper written notice is required. So the Texas Property Code requires proper delivery of the notice to vacate as well. The notice must be in writing and give at least 3 days notice of their request for you to vacate the unit unless the lease allows for a shorter period. So that's where, or a longer period. So you definitely want to look and see if it's a 24-hour, 48-hour, or even a 30-day notice to vacate that's required. Now, once they draw up this written notice, they have to provide it to you in a very specific way. They either have to hand deliver it to you in person, they can mail it to you, and they should post it to the inside of your front door. In the event that they claim they can't do any of those things, they can post it in an envelope to the outside of your front door. But they also have to place a copy in the mail by 5 p.m. on the same day. So if you get a notice outside of your front door, take a picture of it before you take it down. Your landlord must also prove up certain circumstances in court to justify why he couldn't hand deliver, just put it in regular mail or post it to the inside of your front door. So you want to make sure you mark the day, understand what's going on, take a picture so that you have all the evidence you need before you go to court, but also so that, you have proof of the dates that things happen. The landlord can date a letter, but you can date when the photograph is taken. So just any type of, however you get the notice, you want to make note of it and read it. Now, under the CARES Act, covered properties are required to give a 30-day notice to vacate. Covered properties are defined as if the property participates in a covered housing program under VAWA or the Violence Against Women Act, or the property gets some sort of federal funding. Now, this is either public housing, Section 8 housing choice vouchers, if they're project-based housing, even rapid rehousing, low-income housing tax credit. This is not a full list. But there are a lot of programs, covered housing programs under VAWA. So you want to make sure if your landlord is receiving any of those or receiving them for your unit, you investigate that because they will be required to give you a 30-day notice to vacate prior to moving forward with the lawsuit. This is also required if they have a federally backed mortgage. So these are Fannie Mae, Freddie Mac, FHA, or VA loans, for example. And this includes single family homes, duplexes, mobile homes. And so for larger properties, for example, some databases are available for a quick search, but not all have been updated. You're going to want to check your county's real property records, or you can request this information through the discovery process if you go to trial in order to see if your landlord is in fact a covered property.
You accidentally muted yourself. Okay.
Excuse me, my work phone's connected to my laptop. So it was ringing. So like I said, you'll definitely want to check your real property records or request the information through the discovery process, or let your legal professional or anyone that's helping you out know that's something that might be an option. Now, what else might happen when the lease is breached? Your landlord could perform a lockout, or they could even try to threaten you with a utility shutoff. Like, I'm going to turn off your water, I'm going to turn off your lights. They're not allowed to do that. Your landlord cannot intentionally exclude you from your unit or home unless it's for bona fide repairs, construction, of course, an emergency, removing contents abandoned by a tenant. And if the tenant is behind on rent and the right to change locks is in the lease and proper notice has been issued, they can perform a lockout once every pay period, or if they go through courts and the judicial process gives them an order allowing them to put a lock on the door. Your landlord also cannot intentionally interrupt your utility services unless it's for bona fide repairs, construction, or emergency. And in that case, you also should be receiving notice. Now, even if you are behind on your rent payment, you do have access to 2, judicial remedies if your landlord intentionally and illegally locks you out of your home or shuts off your utilities. In the event of a lockout, the lawsuit you would file is called a writ of reentry. And again, this has to be allowable under your lease. And if it is, your landlord must provide you with proper notice as required in the Texas Property Code. Your landlord is required to notify you of contact information, a phone number, a contact for an agent that is available 24/7 to come and remove the lock. And once the request has been made, within 2 hours of the request, regardless of the time and date, they must return and let you in. And FYI, they are not required, and you are not required to make any payments to the landlord in order to be let in. So if you are kept out of your home and you aren't allowed access in, you've made your requests, and you're still locked out, you do have the option to file an eviction lockout writ of reentry lawsuit against your landlord, and we'll go over that more. And in a utility shutoff situation, a writ of restoration, that's the name of the lawsuit you would file in order to get your utilities restored. Now, when you've been locked out, if your landlord fails to let you in, you remained locked out of the unit, then the writ of restoration lawsuit can be filed stating the facts of your case under oath. Now, this lawsuit will need to be filed in the county, in the precinct where the home is located. Now, once filed, the case will be set for an ex parte hearing, which means you do not need to serve your landlord before, prior to this hearing. So you don't have to serve them citation when you file it. Now, when you go to your hearing, if the judge agrees that you were illegally locked out, you'll receive a writ of reentry ordering your landlord to let you into the home. That is a document that you must now give to the constable to serve on your landlord. Now, if you've been locked out, damages can be recovered, which is a civil penalty of 1 month's rent plus $1,000. Any actual damages or expenses, like if you went to a hotel or had to, rent a room, court costs and reasonable attorney's fees, less any delinquent rents or other sums. There's also an option to terminate the lease if it becomes a problem. When your utilities have been shut off, it's the same process. You're going to want to file a lawsuit in the precinct where the property is. You'll file a writ of restoration lawsuit, and you do not have to serve your landlord prior to this hearing, but you will file your petition stating the facts under oath. And at the hearing, if the judge agrees that your utilities were disconnected illegally, you will receive a writ of restoration ordering your landlord to restore the utilities. You must then take this document to the constable to have served to your landlord. Damages can also be recovered when your utilities have been shut off. You can recover actual damages. So if they cut off your water and you're buying jugs and you're refilling gallons of water, or you had to change the food so that, your kids could eat because your electricity was turned off, keep those receipts, keep all of that information, because you may be able to recover those in the suit. You can also get 1 month's rent plus $1,000, reasonable attorney's fees and court costs, less any rent you may owe your landlord. Now, as a separate issue, we'd like to mention the security deposit. It's a completely separate issue from your rent, so you can't ask your landlord to use your security deposit to pay 1 month and you move out. No, your landlord can only keep and deduct from the security deposit amounts for damages and charges for which the tenant is legally liable under the lease or as a breach of the lease. Generally speaking, your landlord can't retain any portion to cover normal wear and tear, and if they keep any or all of the security deposit, within 30 days that the tenant surrenders the unit, you must receive a written description and an itemized list of all the deductions, unless the tenant owes rent and there's no controversy concerning the amount of rent owed. Now, in order to get your security deposit, your landlord must have a good forwarding address for you. So make sure you give them a good address in writing. But we just want to make it clear that if there's no, if there's just normal wear and tear, your landlord should be returning the deposit to you unless you owe any rent. But if they don't, make sure you give them a good address so that you can get a written description and itemized list just in case you have any disputes in the future as well. Now, to the meat of the situation, evictions, which are also called forcible detainer suits. These are controlled under Texas Property Code Chapter 24. An eviction's primary focus is to deal with the right to possession of the property. So your landlord has to prove up certain elements, that they own the property, they have to prove that they are the owner, or, you know, an agent of the owner with permission to file suit and standing to file suit. Now, they also have to prove that they provided you proper written notice, like we discussed, in one of those fashions, and that you received it and refused to leave. So make sure you pay attention to the date the lawsuit was filed. If your lawsuit's filed on the 5th and they gave you to the 8th if you were given a notice to vacate on the 5th and you were given until the 8th to move, and then your landlord files on the 8th, there's an issue there because they didn't give you enough time to leave, so they can't say you refuse to leave. So you definitely want to pay attention to that and receive your citation and look at all that information that's filed by your landlord. Now, evictions deal primarily with possession, but the landlord can add a claim for any back due rent amounts. But the landlord can only ask for base rent. Late fees, past due utilities and other sums, trash, water, admin fees, if they want to pursue that, they have to receive it in a separate lawsuit. And that's a small claim suit that they would have to file separately. So always pay attention. You might get a citation or information that your landlord's only suing for 2 months of base rent, but your ledger might say differently. And that's why your ledger is probably going to include any late fees, any, costs that you acquired over time in the unit, any type of utilities and stuff. They can ask you for that to stay in the unit. However, in the lawsuit, they cannot ask you and receive that from the court. You also have a right to a jury trial, but those filings must be timely and a fee must be paid unless you file it with an inability to afford court cost form, which we'll talk about. Now, also, if you go to court and you are unsuccessful, you do have access to the appeals process. Within 5 days of the court date, if you choose to appeal, you can request an inability to afford court costs and fees form. We call it an IFP. You can get that from the clerk. You need to fill out the form completely and under oath and return it to the clerk. If you choose not to appeal, but choose to vacate or enter a settlement agreement to vacate the unit, if you don't vacate, of course, per the agreement, a writ of possession can be issued, or if you do not appeal, then you have to vacate the unit within those 5 days, or the writ of possession can be requested and issued. Now, if you do choose to appeal, and this is a non-payment of rent case, your bond will be reduced down to 1 month's rent. That'll be due 5 days after filing the paperwork. So whenever you file the paperwork, you're going to want to count 5 days, including weekends, and that's when you'll have to make that payment to the court registry. In order to maintain possession of the unit, that's what that payment is for. And then your case will be transferred to the county court and assigned to the county civil court at law and assigned to a court. So even if you do not pay that 1 month's rent to stay in the unit, your case will still go to county court. So you will receive paperwork in the mail, so check it regularly. And if you file with an IFP form, you don't actually have to file an answer, but if you do have things you want the court to know, you definitely want to file an answer with the court after receiving your paperwork. Now, with the non-payment of rent cases, when they're filed with the inability to afford court cost form, monthly rent payments must be paid into the court registry as it comes due. So that's usually the first of the month. But of course, if you have an agreement with your landlord to pay on the 10th or the 15th, then that's when your payment will be due. Failure to make that rent payment, this is important, so I don't know why it's so small, sorry, but failure to make that rent payment may cause you to lose possession of the unit, but your case will still be set for trial. So if you move out prior to trial or anything like that, your case will still move forward. And if you lose possession by failing to make those monthly payments, your case will still move forward. When you are in county court, if you appeal and everything's perfected and you go to trial, the case is going to be heard what we call de novo, or from the beginning. Justice of peace courts are not courts of record, so there's no need to tell the judge what happened last time. This case is being heard brand new from the start. So anything that happened before, just make mental note of it and then pay close attention to what the landlord is doing in court, because they also have to start over and prove up their case. The landlord must provide testimony and evidence in order to win in county court. That said, if you're still unsuccessful, you will have 10 days to either appeal or pay the appeal bond, or the writ of possession can be issued. The cost of an appeal from county court is usually 10 times the monthly rent due in a lump sum. And just FYI, some courts will allow for an immediate writ of possession to be issued after the trial if you don't make those monthly payments and it's requested. So if you're unsuccessful in county court, you need to move out within 10 days, or in certain situations, depending on what's requested, within 5 days, or the landlord can obtain a writ of possession. That writ of possession will then be posted and you'll have 24 hours to vacate the unit before the constable comes back. And so you also have an opportunity when in county court to talk to your landlord and see if you can negotiate any type of move out agreements or settlement. So always take that opportunity to show up to court and advocate for yourself, just to see. You never know what happens. And that brings me to my additional tips. Get ahead of the problem. Talk to your landlord as soon as an issue arises. And even when you're in court, talk to them before trial to see if you can come to an agreement. You have to get ahead of the problem. Your landlord is a person, they're running businesses, but they're still human too. They might give you compassion, but avoiding them altogether, we've seen, doesn't help the situation at all. We understand that it can be a very depressing situation, especially if you hit on hard times and it's affecting your housing and where your family can stay. It can be embarrassing or sad or frustrating, but once you get your bearings back, get ahead of the problem, talk to your landlord, or look and see if rental assistance is still available. You want to check your local organizations, call around, call 311 and see if anyone's still offering, even if it's $500 and your rent's $1,000, or if it's 1 month instead of 2 months, anything helps. Just make sure you get out and start looking for those things so you can avoid issues in the future. And if you're having issues with the condition of the unit, pay your rent and then contact someone for help. You do not have to live in squalor. You don't have to suffer in silence. So pay your rent, contact someone and see if we can help you follow the steps to get some of those repairs made or to get you out of the unit. Thank you for your time. Some online resources are texaslawhelp.org, and you can go to our website, Lone Star Legal Aid. We do have some eviction resources on there as well. Attorneys, if you have any questions, you can email me at kdike@lonestarlegal.org. Tenants, you do have to apply for services. Our services are free to those who are eligible, so you'll have to go through an application process. So make sure you call toll free or call your local office or visit us at www.lonestarlegal.org. Thank you.
Okay. There aren't any questions in the chat. However, I do have a question. When you were talking about a writ of reentry or like when you're having to sue the landlord for payments and things like that, for letting you for locking you out and stuff, how long generally does all of that take? Like, because if you're locked out and then you have to go through and then file the lawsuit or to gain re-entry, what's the timeline on all of that?
It depends. It usually depends on the court, but it won't take more than a week to get a hearing. Once you file it, you can contact the court and see how soon you can get put on the docket. And you do have, I don't want to say, but you do have options. There's 2 courthouses per precinct. So you can also call and see which one might give you the fastest date. But it's usually within 5 to 7 days. Since it's an ex parte suit, you don't have to serve the landlord, and which is usually what takes the most time in lawsuits, is finding and serving the other party. And so the court avoids that to a certain extent by having a quick turnaround on those filings, by making them ex parte.
So if someone is facing an eviction like right now, what's like the first step that they need to do as far as contacting you guys, or what do they need to do? If they just got the notice.
If they just they just got the notice yesterday, they want to look at the notice to vacate, see what their options are. Some letters tell you come to our office and talk, some don't, some give you resources. So make sure you read it, note the date, keep a copy. My always my first go is to talk to your landlord, see if you can get an agreement going. Always follow up with something in writing, maybe an email. And then if you do have a strenuous, tenuous relationship with your landlord, you definitely can always reach out to any type of legal aid organization. There are several in the city, the law schools here, Houston Volunteer, lawyers, Lone Star Legal Aid. We're all available to assist in giving information, but you definitely want to hit the ground running because it'll be 3 days notice, then they can file the lawsuit. They can file the lawsuit at any time. They can file it on the 4th day, they can file it on the 10th day, they can file it on the 30th day. So you definitely want to, when you get the notice to vacate, that's when you kind of want to start asking questions, because by the time you receive the citation, the eviction's been filed, it's now public record, and our options are wildly limited.
So people need to know that the notice to vacate is not the actual eviction.
Correct. You'll have a notice to vacate that comes from your landlord, and then if your landlord moves forward with the eviction, the citation will be something you receive from the courthouse that's given to you by either the constable or posted to your door. So that's where you'll know the difference. One of them will be from your landlord, that's your notice to vacate, and one of them will look like it came from the courthouse, from your JP precinct. And so that's how you know a citation. That's how you know a lawsuit has been filed.
So I've seen where some people make that mistake quite often. They receive the notice just because they haven't, their rent is late. And generally everybody gets the notice to vacate if your rent is more than past the grace period, if it's a 3-day, 5-day or whatever. And then they just automatically assume, okay, I gotta move. And then they pack up and they leave because they think that's the notice to actually, be evicted. There's a question here. If a security deposit wasn't required upon move-in, can a landlord ask for a security deposit years later?
When your landlord does not require security deposit upon move-in, you kind of just run the risk of having to pay out of pocket for any damage above normal wear and tear. So I don't know if they're asking you for a security deposit because they forgot to ask you for one, or if they're asking you for a security deposit when they just mean you need to cover damages to the unit. So that's the risk you run in those situations. When you have those 0 security deposit move-ins and it sounds all great and amazing, upon move out, you might have to suffer the cost of paying the rest of that out of pocket.
There isn't any additional after that, so I'm not sure what the situation is. But
Situations are-
what happens if in a situation kind of similar to this, when you move in with one property management company and then the owners switch property management companies, and then now they want to charge you different fees for different things that weren't in your original lease? So are they allowed to do that?
Allowed to, I want to say yes. It depends, I think, on how they do it. So it depends on what type of notices we're given. So if you're given community rules, and you know how some places give an itemized list ahead of time, this is the cleaning fee, this is the trash fee, this is the furniture removal fee. Keep a copy, always keep a copy of those things, so that you could argue, right? Because without certain facts, you could argue that they should respect the amounts quoted on your original when you first signed the lease, but depending on what type of notice was given during the changeover, that might affect the answer to the question.
If a tenant is trying to pay rent, but they're dealing with a landlord that really wants them gone and they refuse to accept their rent, what do they do in that situation?
Is the rent late, or are they denying
They just don't. They're denying on-time payments because they don't want to take the money because they want them to move.
That may rise to the level of a constructive eviction, which is them essentially creating a breach. So you definitely want to reach out to a legal professional so that they can understand the facts. This is fact specific. They want to understand the facts before you end up in a situation where they're not allowing you to pay, and then they still have the audacity to file an eviction lawsuit against you for failure to pay. So in that span, you got to hit the ground running and stay on top of it, because that's a scary place to be. But that is a problem, but it is, I think, more fact specific than just saying what could happen.
Okay, another question here is, what is considered normal wear and tear?
So it depends, right? Because I live alone with a dog. My normal wear and tear isn't going to be the same as someone who moved into a 3-bedroom with 4 kids. My wear and tear might be very different, because what I've noticed, I've worked from home since COVID started. So what my carpet looks like after a year working from home, pounding the same bedroom over and over again, is going to look a lot different than if I left the house and was at work for 10 hours and then came home and made dinner and went to sleep. So it is that one is also fact specific, but I also want to say, advocate for yourself in those situations. So my wear and tear for working at home, I am going to have my carpet replaced, which in a normal sense, someone leaving the house for 40 or 50 hours a week isn't going to have the same. So I would have to advocate for myself, saying, for someone that works at home 50 hours, this is my normal wear and tear. So I would say in those situations, try and pay attention to what's being alleged, take videos, pictures, open the cupboards, open the shower, open the toilet, especially if you have a lot of kids. I always say that, because yeah, there is normal wear and tear. If you rent a house to 7 people, you can't expect for it to be pristine when you come back. So that's why I say it's all dependent, but definitely depending on how that conversation goes with your landlord, advocate for your circumstance, because normal is relative.
Okay, another question. I had a real estate client of mine that was moving into a leased house. Landlord promised to get everything clean, then cut the yard and all this other kinds of stuff or whatever. But then the landlord said that it was done, but it just wasn't done to the standard of the tenant. But it really wasn't cleaned at all. So what does a tenant or a potential tenant, when they're getting ready to move in, do in a situation like that? When something's not repaired the way it was supposed to be repaired before they moved in?
So my suggestion is to, this is experience based. One, if you're having a conversation with the landlord and you haven't moved in yet, promises for repairs are being made, promises for upkeep, especially if they're not just cosmetic. Painting the baseboards, probably not going to get you anywhere. Repairing a light fixture in a bathroom, and the only bathroom in the house, different story. Get it in writing, because all of these are still contract based. Because I have seen certain leases that say, if the home isn't ready for move-in with, X type of damage, then within 10 days of looking for a fix, someone can terminate. Check your leases for that type of language, especially if there's language that says if you take the property early, or if you take the property as is, it has to stay as is. Look for those type of clauses. But especially if it's a side conversation, especially when you say like those real estate brokers, those single family homes, if you're having those cute side conversations about the fence being fixed up, get it in writing. Get it in writing. And then also say, even some language like, if I can provide photographic proof that repairs were not made within 5 days of me moving in, I have a right to terminate and give you 30 days notice. Create it. Lawyers aren't the only ones that can create agreements. Just know it's about knowing that you have a right to make those requests. You have a right to say, I want it in writing that you're going to fix this. And if you don't fix it, I can move out. Things like that. So it's always best, before you obtain anything, make sure any promises you have are in writing. Make sure any type of information in your lease speaking to repairs or wear and tear or occupancy of the unit, know it. And if you don't know it, call someone to know it. Call us. Someone can read over your contract, advise you, especially the ones that are 20, 30 pages. I saw one file the other day was 82 pages long. Like, we get it. We get it. But if it's in there, then you need to know it, because that's what you're agreeing to. So definitely don't make those agreements without having some type of ironclad agreement that if this is not up to par, X, Y, and Z will happen.
Okay. If is the tenant still kind of on the hook for a lease that you signed, but you never picked up the keys and paid like your initial deposit or initial payment or anything like that? Are you still locked into a lease or can they walk away?
It depends on the lease terms. You want to read the lease you sign because usually they'll tell you, most leases do contain language about if a tenant doesn't move in or if the landlord precludes a tenant from moving in and all of that. So that's going to be in your language, in your contract language. So read it, discuss it, ask the questions ahead of time because you might be bound. If you signed it, you might be bound to the terms and you might be bound to any type of penalty contained in the lease if you don't move in.
Okay, another question here. If utilities have always been in the landlord's name, can the landlord require tenant to put utilities in the tenant's name? And if refused, can landlord close their utility account, leaving the tenant without utilities? Is this the same as illegal shutoff?
They might want to apply, but for legal aid, I want to say essentially a landlord can ask you to put the lights in your name if it's contained in your lease. So it will be, that's a fact specific question. And so it would have to, be based upon notices and things like that. But as long as they're not hindering you from putting it in your name, generally speaking, that's not the same thing as cutting your utilities off.
Yeah, I've seen in some leases where they say you have X amount of days to get utilities turned on in your name. Otherwise, then yeah, they will have it shut off in their name because they're not the one using it. They're liable for the bill then at that point.
Yes. And you also want to know if it doesn't say that, or if it says your lights are going to be in the landlord's name through the duration of the lease, that can also be there. That's why it's fact specific. So it's what's in the contract,
It kind of depends. Okay, that was all that kind of actually came to mind. And I think those were all the questions that we had in the chat. Ms. Seymour, were there any other questions that you had? No? Okay. All right, Ms. Letty, are there any other questions that you may have? Because the one question that was emailed to me prior to that was, you had already answered that for me. So that's all I've got. And I don't see anything that's on Facebook either.
Okay, I'm sorry. I couldn't unmute. I couldn't find it. This is Letty. Like, dog, okay. They're gonna be gone in a minute. Thank you all. This is awesome topic. My first question had to do with, I guess, is it ever too late to ask for a security deposit or to be asked for a security deposit? Or if, hey, once it never was asked for, can you a year from now, 2 years from now, ask for it now? That was the clarity, I guess, needed on that.
I haven't seen that issue.
Okay.
I don't know. I haven't seen that issue, but I'll make a note here. And I actually need to go over the note I made last time.
There's always one question.
Yeah. Is there a cutoff period for asking for a security deposit? I guess that might be a better way to sum it up. And if they haven't asked for one in, a certain amount of time, grace period, year, whatever, then they can't come back and request one. So that was the question. And with the utilities one, although not in the contract, a written notice was, given to say, as you were saying, our second person was saying that it was in writing, but not in the contract, that after so many days, this is being asked, for you to do. Did the tenant and does the tenant have the right to say, I don't want to, I haven't been doing it and it's working? That was kind of the thing.
I think my initial, or just my gut reaction is more so, if it's in the initial lease term, then no, they cannot alter it. But maybe like a lease renewal as a requirement to renew the lease, I can't think of why they couldn't ask for it
Okay.
as
Okay.
part of, as part of a renewal process.
Mhm. If a lease is not renewed year to year, does that mean that the tenant is a month-to-month tenant under the same exact contract that they didn't, re-up?
Yes, if the lease rolls over into a month to month, then the lease terms remain the same unless notice has been given of a change in lease terms or a notice of you're moving month to month and we're not requiring you to sign a lease, but this is going to be a fee. In certain situations, they provide that type of notice. I do see it can be enforceable. But if it's just a normal like lease that's just been rolling and rolling and rolling, then it's gonna stay on those initial lease terms unless what do they say, an object in motion?
Yeah, it's gonna stay in motion.
Yeah.
That's
So,
right.
so I would
But
think of it that way. That's
uh-huh.
how my brain thinks of
But
it.
it can be, it can be, that motion can be accelerated. And what I mean by that is if it is in writing after it is not necessarily repeated and renewed, is it a formal letter that says, or someone can like tell me, I'm not doing the whole year thingy, but I want to make this change, maybe an increase in the rent, or maybe a fee increase if the community is not, is there just like an addendum type process
For the
that's
most,
acceptable without doing the whole thing over again?
it would be like, yes, like what I'm thinking, and I'm thinking more so not legally, because I don't want to say it's legal advice per se, because everything always depends on notice and what's contained in the actual contract. So if you're on a month to month, for example, your landlord can give you 30 days notice that next month your rent is going to increase $200, and you can either pay it or you can give notice of move out. So it's
Is that an email? Is that a formal mail that's certified? How is that notification allowable legally so that it has to be enacted upon? Do you know
like
what I'm saying?
okay, you think of it like a notice to vacate. I think those are different. That would be based upon our community rules. Sometimes like there are some laws that say if you communicate through email primarily, or if you've agreed to communicate via email, the landlord can notify you via email. So as long as there's not a contradicting statute that says they cannot, they can. Because it's like most
Okay.
notices I get, you get from your apartment complex, if they're those, I don't want to say friendly, but when they're more of those routine notices,
Mhm.
they're just posted to your door. If it's telling you of a rent increase, of course, I would want them to do it in a more secure way so that they can guarantee that you've been provided notice. But I don't think legally there's a delivery requirement by law for when you make changes to a written contract.
Okay. Okay. Okay.
I think it
And
would
based
depend
on
notice.
based on your history, knowledge, and anyone else who may have, either own homes or have tenants, whatever, is there a particular standard measure of time between increases of rents to tenants, or that tenants have to pay? Should they expect yearly increases? Is there a percentage that's usually,
No,
no? Okay,
no, I already know that they can take your rent up and they could say it's due to market change, just because I feel like it,
Mm.
whatever, they can change their rent increase to be whatever it is that they want it to go. Because I've had that question before too, when,
Yes,
yeah.
you get it a lot.
Yeah.
There's no, Texas doesn't have
Mhm.
I'm not as a tenant myself, I'm not happy about it, because every time they try to raise my rent, I march myself down to the landlord's office and see what can we talk about. But yeah, Texas doesn't have any, everything I see is mostly a reasonable standard, a fair market value standard. But and again, as a tenant, I don't like to expect a rent increase at the end of my year. So it's all on it depends, fact-based status. But if your landlord does intend to increase any type of fee, or if they give you notice of a fee increase, you definitely want to go to your lease and make sure they're giving you the right amount of time, it's the right amount, or see if you made any promises, or if there's any way to get out of the lease if you aren't able to pay the increase, and go about it that way. But it is going to depend on what you originally signed with your landlord. Kind of, it's all based upon notice requirements and what type of tenancy you're in.
But they don't have to give you a justification. This has to be this because, wow.
I mean, yeah, if you end up having a problem, you can have a discussion, I guess, but no, generally speaking, unless your rent goes from 1,000 to 4,000 and they blame market value, I'd have some questions. But in Texas,
Right.
it's like, we didn't do it right, guys.
There is no rent control laws or anything.
Yeah.
So that's why I always say your lease is a contract, especially if you're working with a single family home or just a place where they're having more conversation with you. Ask ahead of time. If you know you're on a fixed income, ask them, do you guys do regular rent increases? Is there any way I can just keep providing you with my fixed income information to let you know? Like, talk to them. I always just say, it seems so scary, but it's not. You're not at HEB trying to get a discount. This is housing. They're going to have you there for a year, 2 years, 5 years, 10 years. So, you can start your tenancy there with conversation and negotiation and being, very open. We all take home a salary. We all go to work for our paycheck. So have a conversation and see if this property is going to work out for you, or if not, and make your decisions that way. But I always say, don't be afraid to have these conversations ahead of time.
Kind of as follow-up to what she's asking about as far as changes and things go. So if you have an initial lease that lasts for a year, you don't renew an actual lease, and you generally kind of go as a month-to-month tenancy. If there are written changes or emails that are sent out notifying you about an increase or a change in fee or a change in policy or whatever, is there anything that states that you are to receive some kind of acknowledgement that you received it? Because they can easily say, oh, well, I told you last month your rent went up, your rent was going to go up. Well, I never got a notice. Mm-hmm. How do you prove you actually gave a notice, or that you as tenant did or did not receive notice?
That's a business owner question, Ms. Nia, because that's a risk you take, but
so there's no law about that, about past receipts that you actually received notice.
Correct. I would say, as a tenant, keep an eye out on your mail. Just as a general rule, ignorance is not an excuse to everything. And so again, it always just goes back to my tip of getting ahead of things. If you know there's going to be a rent increase, or if you have inklings, because after your initial lease term, the rules kind of change, because as a month-to-month tenant, the rules change. There's a different, set of rules for those who, are operating that way. So it all just depends.
With a month-to-month tenancy, your rules can change every month now, because you're not locked into a lease term.
Correct.
So your rent can go up every single month then, if they choose to.
Oh.
Essentially, yes. That's what makes it dangerous.
Yeah.
And Nia, let me tell you, that happened to my husband and I when we were building our house, and we weren't sure when our house was going to be completed. So the last few months we had to go month to month, and that was another nightmare. So within itself, because it can change from month to month how much they charge you. And that's one, a lot of people in a lot of apartments will tell, well, wait a minute, you don't have to worry about it. Go month to month, and really you should not. You should go ahead and work out a 3-month agreement or something, because that month to month, they can change whatever they choose.
Yep.
So once you're on a year, or as you're saying, half a year, you're kind of locked into that. They can't say, well, I know we signed a year, but you're 3 months in and saying, but I want this different.
Correct.
Okay.
Yes, if your landlord tries to do that, check your lease, but also usually the answer is no, especially if they're asking for increased cost. I feel like admin costs, those type of variable expenses can change a little bit, but your base rent or being required to pay new deposits, if your situation hasn't changed, you definitely want to look into your lease. And if you're confused about anything, reach out to a legal professional to review it for you and see what your options are.
Thank you.
Getting an executed copy of your lease. I know a lot of apartment complexes do things electronically, and you generally don't get a copy of that lease until you actually go to move in and you've already signed. But now once you signed and you've gone through all these electronic documents, you don't really know what you signed at the end, or you don't. Never mind, disregard the question. Never mind.
Well,
I
once
just
you-
was really thinking about that, because one of my tenants had to go through this whole process of all these pages, like you were saying, umpteen pages of all of the stuff that they were reading through, and they get the end and it's now submit. But now you don't have a copy. You have to wait till you receive an electronic copy with their electronic signature before you can really print out and see what it is that you actually read. You know, you don't have the option of printing it out and reading it line by line by line, because it's all electronic.
Well, you can. You definitely will want, because like I'm a handwriter, I like pen and paper. Me and my printer have the best relationship. You can ask, hey, or even, let's even start. You can ask for a copy to be printed and mailed. If that's the only way they do it electronically, ask them to use some type of software that allows you the print option, and maybe you can scan and sign it to send it back in, because either way, you're still signing it. And so you're still going to be bound by it. So it's
Right.
better to not look for it afterwards. Oh, I want to read it, but I've already signed it. It's kind of like, well, you're already bound by it as soon as the other party does it. So again, get ahead of it. Hey, I see we've been messaging a lot. I don't mind emailing things, but is there any way we can meet at an Office Depot? Or can you send it here and, so I can get it printed out? It's just easy for me to digest. Ask it, it's easier, but we can't try and get it in writing. And then of course, as soon as all parties sign it, you can send that written request to get a copy of it, especially for some, people who move in a month later or 2 months later. You definitely want to make a request to get a full copy immediately, so that you have that time to digest it and even see what your options are if something comes up.
Okay, another question here. If your landlord uses some of your rent relief money, if you are awarded any, wait a minute. What if your landlord uses some of your rent relief money, if you were awarded any, to go towards legal fees or any fees regarding your eviction?
Oh, that's fact specific. It would depend on the type of organization, any type of agreements that were made, and how they agree to apply those amounts. So I would have to see, or you could look at any type of landlord agreements or agreements that were signed by you and any other party, to see how that was going to be applied.
Yeah.
Could the landlord, could they use it for anything they want to, or is there specific rules to what they can use that award for?
It depends on the organization that provided the funds. They're the ones who would have made that agreement with the landlord. There's no there's no longer any type of general along the, what's the word I'm looking for? Across the board type of application. So it's like I was saying, if there's an organization that's a church and they're just giving you a $500 check, and they're saying, go and give it to your landlord, and it has no strings attached, your landlord could apply it however they wanted to. And if they are allowed to place certain amounts on your ledger via the lease, then they can, because you've agreed to it. So it all just depends on the paperwork.
Okay.
I wasn't aware of that. I thought most of those rent relief programs that were specific for rent and or utilities that were included in I didn't know that was optional.
Yes, because for the state programs or the federal programs that were in place, yes, those had specific rules and they were binding on certain landlords who participated in those programs, but every organization might have their own set of rules. And so that's why, even like I said, you want to even check when you're reading your lease to see, oh, if I am behind on rent, what are they going to add? Some of them will add a legal fee or, you know, a recovery fee and things like that. So you want to know ahead of time what's going to be placed on there. The same way you want to know, hey, if I get this $500 or if I get this $1,500 and my rent's $1,500, am I still going to owe something, you know, or should I use these funds to move? So that, because the programs are constantly changing, and there's different types of local organizations, it all depends on the organization that provided those funds to you.
Interesting. Okay. All right. I believe that is it. Double check.
This was good.
I wanted to answer a question that we asked last week regarding background screening and criminal, how criminal records are recorded and provided. I did want to give information that it is background screening companies can report non-conviction information that is less than 7 years old, as well as criminal convictions, no matter how long ago they occurred. However, there are some federal protections if the information is erroneous or obsolete, because it might, you know, unfairly impact. So there isn't any state laws, but if you do feel like, you know, if you do obtain a copy of your screening, your tenant screening, if you're denied, you're going to want to look through it for those errors and get those corrected. But your landlord can use the information if it's properly provided. However, the federal government does have some rules regarding the background screeners, the reporting agency, not necessarily the landlord. So I just wanted to answer that question from last week.
So they can only they can only add 7 years or younger. They can't add more than 7 years, correct?
No, criminal convictions, no matter how long ago they occurred, they can be, background screening companies can report them. Non-conviction information, like maybe an arrest, that information, they cannot report that information if it is over 7 years old. The criminal convictions can stay on there. But I was just saying that there are federal rights you may have if a background screening company is giving erroneous or obsolete information. So I just want to clarify that your landlord can use those background screening companies and use that information, but if it's incorrect, you might have an issue with the background screening company.
That's awesome. Okay. So make sure you double check whatever they're using to, if they're denying you, ask them for the information so that you can confirm that that is up to date.
Correct.
Are you legally allowed to receive that information that they receive from the background company?
Yes.
Okay.
Yes, you can legally obtain if they deny. The Fair Credit Reporting Act requires the landlord to provide the rental applicant with the name, address, and telephone number of the tenant screening company that furnished the report, as well as a copy of the report.
Okay, that's good to know.
So make sure that if you get denied to an apartment, that you request for that information, for that screening information, and who gave that screening information, so then that you correct it if there are any fraudulent or any misinformation there. It doesn't have to be fraudulent, it just has to be misinformation.
Correct.
Can a
Well, then,
landlord impact your credit if you are late or behind past the due date of your payment of your rent? And how do they do that?
Oh, that's outside my current wheelhouse.
the answer is yes. Not all landlords do report to the credit agencies, but if it's a system that they subscribe to, then yeah, they can report your payment history of your rent to the credit bureaus. If you're late, if you're not late, if you just do it on time, because we were actually looking into that at NRCDC's apartment complex of how to help tenants that had no credit to then started establishing credit by reporting their rent payments to the credit bureaus to help them kind of build credit. So it just depends. Yes, but they can.
Oh, that's awesome. I mean, that's good and that's bad, but just make sure you pay your rent on time.
Yeah. and ask the landlord, do they report to the bureaus?
Yes, that's.
Yeah.
Ask them. And which bureaus, because not all creditors report to all bureaus and all at the same time. So that's something to keep in mind as well too. So
Yeah.
All
So
right.
Nia, you were saying earlier about sometimes there may be, I guess, discrepancies in what is considered taking care of something adequately or fixing something adequately and that kind of thing. I have a question about if it's a home versus an apartment. I think apartments are kind of pretty cut and dry. You have your interior and all of that. But if it's a home, you may have a situation where you may think that is your responsibility, not mine. And I want to say, to help give an idea of it, you don't have an itemized list. You have common sense and you have general language, but it may be something like cleaning out the gutters. It's not a repair of a roof. It's not cutting a tree, understand that. But what if it's something as maybe simple or complicated as cleaning out the gutters of the home? Is that something that's general care of the home? And how do you work around those nuances?
I don't think there is such thing as general care though. Is there? Because is there a standard?
I would think when it comes to single family homes, most leases will establish which party is required to take care of that type of maintenance. They'll let you know who cuts the grass, who's responsible for the tree trimming, who's responsible for cleaning the gutters. So ask before you move in, because if they're making it your problem and you're like, I don't know who to find, maybe it should be something that they find, but you pay the cost. Or you can say, I don't like your cost, I want to find mine. But everything just depends. That's why we start off with leases or contracts. Contracts are between two parties, require a meeting of the minds, mutual agreement and consideration and everything. So before you move in, ask, this is not an apartment. I don't clean gutters. I've never changed a light bulb. I've never had to replace a battery in a
Right.
alarm. I want to get all of that taken care of now, so that when my smoke alarm goes out, I know who to call. Even if it's my responsibility, I know if it starts beeping, I don't need to call him. I don't need to call, the landlord. I need to call my handyman. Yeah.
With the city of Houston, a lot of people, a lot of renters, especially single family homes, they say, well, who's supposed to cut the grass? Well, let me look at your lease. And the lease should say who does that. And if it does not, we always anyway hold the property owner accountable to anything that is, held accountable with the property. So, if the lease doesn't say, we still have to send a notice to the property and the renter anyway, because they're both responsible. So that's how the city of Houston does it.
If there's a HOA and there is HOA responsibilities and there's a general clause that's like, don't violate anything, that's like Kimberly was saying, community, and that is something that it would be a type of that, then would that be umbrellaed, or is that something that has to be itemized and said, the yard, the lawn?
It has to go to the tenant. I mean, the tenant would know. The tenant didn't receive the HOA bylaws or anything like that. The property owner does, and they have to communicate that with the tenant.
That's right. And it needs to be on the lease. If it's not, it's still the property owner's responsibility because they own the property. And you cannot expect a tenant to say, okay, this is an HOA and I'm still responsible for A, B, C, D. It's your responsibility. You own the property, so you're held accountable. If you want the owner, the renter to do something extra, then you need to put it on the lease.
And always know if your landlord ever puts anything in your lease that says, for example, the HOA, oh, you're going to be responsible for HOA, then they need to provide you with the HOA rules, the HOA costs, what they're responsible for, because it's, even if it's a general clause, if it even a tinge of it lends itself to a tenant being responsible, ask them ahead of time. Let me see what the HOA sends you. Then there needs to be something in here that says when the HOA sends it to you, they send it to me as well. There needs to be a clause in here that says any HOA notices you receive must be sent to me within 24 hours. Anything like that. I always say for the single family homes, for the individual, those arm length renters, the reason why you do that is for the flexibility. Then be flexible. Get your Simone Biles on. Ask the question.
That's good.
Get the information, because ignorance and just as call a spade a spade. Usually if it's general, it's against the tenant. So if it's general, ask as many questions as you need to. Be annoying. I always say that. Maybe it's the attorney in me that I love asking questions. Be annoying. You're going to be paying these people. They're going to be in charge of coming in and out of your house. They're going to know where your kids live and go to school. Don't be a stranger. I don't know who likes to move every year, but if you know you need to sit down and get your kid through high school, ask the questions that need to be asked. Know yourself. I'm not mowing a lawn. I don't even know. I'm not finding a landscaper. What is the landscaping package? Let's just get the number out the way, put it in the lease. Here's your $25. It's just, I hope these series make you guys feel more empowered to understanding how much you can advocate for yourself with no shame. You don't need a lawyer to come in there and wag their finger. You can go in and have a good, happy conversation that's easy and where both parties get what they want. I'm renting, you're giving, everyone's happy. Let me be here for 5 years. Go about it. So it's always, if it even smells funny, looks funny, if there's 2 words that you don't know the definition for, hey, can I get 2 days to look at this? And call someone. Call your friend who knows the biggest words, your friend who has a friend, call anyone, but just understand that you do have the ability to advocate for yourself. Contracts do not have to be, cut and paste. Yes, some are, and you can walk away from those. If you know you have a specific situation, advocate for yourself. Tell someone, if you don't get paid on the first, you don't get paid on the first. Say, hey, if you want full rent on time, I need to the 10th. And if it doesn't work, it doesn't work. But it's always about ask the questions, advocate for your own circumstances, get ahead of your problems, and it'll make any type of hiccup, any type of life issue go by a lot more smoothly if you already have this kind of understanding with these people that, hey, we're all in this world. We've seen how the world can change in a matter of moments. So just do that for yourself.
Thank you.
FYI, Kimberly, if you find somebody that's cutting grass for $25, please let me know.
Right?
You see how you don't care.
Yeah, that's I don't know if kids are even, the kids don't even charge $25 to cut grass.
No, ma'am. But if you are renting a home and you feel like the landlord is being not respectful and asking you to do this and do that, and on the lease it wasn't, make sure to call 311 and let the city of Houston come in and make the investigation. If the refrigerator is not working, if the air conditioner is not working, if there's leaks in your house, if something is going on and it does not feel right, doesn't, call 311 and let a professional come out and make an investigation. Now, a lot of times, if you don't have an updated lease, a landlord can evict you. But let me tell you something. That will stop. The landlord will have to have all the violations corrected before he can move anyone else in. So you may say, well, I just got evicted and I'm sorry because the landlord didn't have X, Y, Z. We got it inspected. He got a notice. Well, let me tell you, he cannot move anyone into that apartment or that home until all of those violations have been corrected. So he's losing money in the process anyway. So make sure you read your yes.
If somebody's living outside the city limits, if they're in Katy, if they're in Humboldt or something like that, and they don't have a Department of Neighborhoods, who do they call in those respective areas?
Those counties have Department of Neighborhoods. They have code enforcement officers also.
Code enforcement.
So call the code enforcement officer division in those sections, in those areas.
All right, good.
Yeah, know that you're not alone. You have someone that will help you and will walk through that process.
Okay. Cool. All right. I believe that's it.
Thank you.
We've had a wonderful conversation. I really appreciate this. This has been great. Kimberly, once again, thank you very much. We'll be waiting for our answer next month on the question that we have for this month. So
I got you.
It's always one that comes up. Each month, it's always something that comes up from the month before that we didn't never think about, or something that kind of in between now and next month, we'll get another question that's going to come up and we're going to ask you something else. So yeah.
Isn't that how we learned though too? I mean, it seems like when we first started, we didn't know half of these answers that we're going, oh no, this is what you can do. Oh yes, you can do that. No, you cannot do that. They can't do that. But guess what? It took the process of us learning also.
Absolutely.
So this is all an effort and we're all learning and growing. So thanks everyone. This is what it's all about.
Thank you guys. Thank you very much for tuning in. We really appreciate you guys for being here. Kimberly, thank you once again for taking time out this afternoon. We know this is during your billable hours time, so we appreciate you for coming out and actually doing this and providing this information for us. We really appreciate it. We appreciate the partnership and the support of all the participants that come back and watch us and join us every month. Thank you, Miss Letty. We really do appreciate your input and your questions as well too, Miss Simone. Seymour, I called you Miss Simone. I've got Simone Biles stuck in the head now since you said Simone. I see Seymour, but thank you very much. Maylin, thank you. Miss Monica, thank you very much as well. Miss Grace, we see you guys there. We hope to see you guys again next month. If you have any other questions, please feel free to come back as often as you like. For the most up-to-date information, Myra and I do not keep up to date with all the laws and all the changes and so on and so forth, which is why we bring the professionals to come in every month to let us know what's going on, what's changed, what's the latest, what's the newest that we need to get out there. So it's something new that we learn every single month as well. So let's see what we got coming up. Unfortunately, our workshop for tomorrow has been canceled, our home maintenance. If there's anyone that was looking forward to participating in that workshop, I will be sending out the recording for that presentation. Yes, you will get a copy of the recording of this presentation as well, along with information from our legal partners and eviction information. Does the Texas, that there is no more rent relief programs that are actual out there, not the ones that were funded specifically for COVID relief, right?
Houston Harris County program still has funds. I think they received about 4 million to still give out, and they have a new eviction process. So you do not even, I think you have to have proof of a delinquency, but you don't necessarily need a notice to vacate or an eviction to be filed to go on the website and follow the prompts to apply, but your landlord does need to be participating. They have to agree to participate for those funds to be released directly to them.
Okay, and then I will look that up and include that link on the recording that I sent out to everybody as well, so that you'll have that information. And also, we ask that you guys forward it, pay it forward, provide it to anybody else that also may find any of this information to be beneficial as well. Share it with somebody that weren't here today, or don't necessarily know if they may have questions too. So thank y'all very
And-
much.
Hey, Nia, we're also having coffee and conversation next Tuesday, virtually and in person, and we'll have Lisa Nelson talking about transfer on death deed, how to fill it out, what it is, how you can benefit with the transfer on death deed. And we'll also be at the A-Leaf Neighborhood Community Center on Bel Air from 10 a.m. till 12 p.m. October 24th. Tuesday for coffee and conversation. We'll have some donuts, some coffee, and you will see me.
See, that's why you had to go out. That's you got skipped out just in time. We didn't hear that part. He's trying to put me
So
on
if
the
you
spot.
want to see us, we will be there.
We'll be
Work
there.
it.
We will be there. Indeed. All right, y'all. Thank y'all very much. Go out and enjoy this amazing weather we are having today while it lasts. You guys take care of yourselves and stay safe, and we will see you all next time.
Bye, everyone. Stay.
See you in a couple of days, Kim. It felt like, it was just yesterday. This month went by so fast.
See, right, November's right around the corner, the way this one moved. You guys soon.
Stores already. Oh my goodness, all this Christmas stuff.
Yes.
Indeed,
We
indeed.
really did. It seems we're going by October, and now it's just 2 weeks. It'll be November. So
Yeah. All right. Thank you, Miss Grace. All right, you guys take care. Have a good one.
You too. Bye, guys.
bye-bye.
Oh, thank you, thank you. Where is she at? I want to see. All right, that is it. We are out.
Turn it off. Turn it off. Turn it off.
Hold on, baby.
You still